the appellate division and by the lower court is their reliance upon the line of cases dealing with the so-called innocent co-insured. The appellate division opinion talked about how there were two lines of cases, one permitting recovery, one denying recovery, where there were two insureds, one of whom committed an arson or a fraud, and the other of whom was innocent. We say this is not a case involving an innocent co-insured. The questions involved in that type of case are completely different from the questions involved in this case for a number of reasons. In the first place, most of the innocent co-insured cases involve a husband and wife and a tenancy by the entirety. You know, it's a relationship which is created for a bona fide purpose. It's maintained for a bona fide purpose. The insurance coverage is obtained in both names for a bona fide purpose. In this case, the creation of the interest of Cheryl Ann in the property was hardly for a bona fide purpose. The conveyance to her was of property, the title to which was totally unmarketable. The proof in the record by Attorney Wolf is that there were something like $150,000 of outstanding liens. Excuse me.
This was, you couldn't show this was a fraudulent conveyance, did you?
I believe it was a fraudulent conveyance.
Yeah, but did you have a right to attack that? You weren't a creditor.
No, we do not take that position. We only suggest that that is one of the elements which goes to the question of whether Cheryl Ann was a bona fide owner of the property or whether this was simply a scheme.
But could you attack that?
I don't
Only
think
a
we
creditor
could.
right?
The creditors could. We
and
do not
bank,
take.
they went ahead and paid off the mortgage, didn't they?
Well, we paid off the mortgage.
Yeah, but the bank did really.
Yeah. But to answer your specific question, we have not taken the position that we could attack directly the conveyance as a fraudulent conveyance. The point being, however, that in conjunction with all the other facts in the case demonstrates that at the time of the fire, this was a piece of property that she could not sell. It had a $180,000 mortgage, $150,000 in liens. It had been purchased about 2 years prior to the fire for $150,000. The whole purpose of the conveyance to her was, we say, in furtherance of this device under which Russell Reed was going to burn the property and have her as the conduit for the funds back to him.
Wasn't that contention rejected by the jury?
The way the jury had to determine the issues was there evidence of knowledge and consent by Charlene as to the acts of her father. That's the way it was presented to the jury. That is not the way that the issues are created in this case. And again, in the innocent co-insured cases, the issue is, did this co-insured know that the other insured was going to set fire to the property? Was there complicity? Was there not? We do not say there is any evidence that Charlene set the fire, that Cheryl Ann knew the fire was going to be set, that her father told her that he was going to set the fire. There's no such evidence.
Thank you very much, Mr. Holmes. Mr. Wade? Yes, sir. Why shouldn't the jury have been able to try to construct some kind of relationship between these two in this enterprise?
Well, by the trial judge's rereading of the charge relative to intent and all other aspects by which the jury, circumstantial evidence by which the jury could have drawn such a conclusion, they nevertheless rejected it. What I think is
But the judge did not charge anything about any constructive kind of relationship.
Well, that would not have been a matter of fact to the jury. That would have been a question of law. If we analyze this, there was only one of two ways for the trial judge to go. Either to permit the jury to make its determination based upon the charge as it recited to the jury, or to make a determination as a matter of law that the acts of the father would be imputed and transcend the rights of the daughter under the policy. There wouldn't be a question of fact.
The court said that it was referring that very question of fact to the jury.
it created a question of fact for the jury, and in effect gave the defendant another right to have the jury make such a determination.
Well, it seemed to believe that it was creating that as an issue of fact, and yet the charge is quite different, is it not?
Well, Your Honor, whether in fact it does constitute a question of fact for the jury, I'm not prepared to argue. Judge Burchell felt that it did and gave
Did you
the jury...
object to that at the time?
No, I
Did you
did
say
not.
that that should not be the fact put before the jury?
I don't object to it now. I'm just commenting as a matter
Now,
of...
once it's done, of course, it becomes the law of the case. Whether or
Yes.
not it should be a matter of law is irrelevant. It is a matter of fact in the context of this case.
The position that I vigorously opposed was any determination by the court that the acts of the two were united. They, in fact, had separate interests, and based upon the common law on the subject, the jury, in fact, assuming arguendo that the jury had come back and found that the acts were imputed to the defendant, to the plaintiff, Cheryl Ann, I feel that I might have had a right to argue as a matter of law that it was improper to put that to the jury for their determination, in all candor, Your Honor. I did not, in fact, make that recitation before the trial judge at the time because I felt that there was no way that the jury was able to tie in the acts of one to the other. If the court, please, I'd like to spend a moment on the question of the mortgage situation, in the event I run out of time. Mr. Holloway stated that the appellate division did in fact deprive him of the right of set-off, and I think there are three factors that we must look at. As stated by Judge Iba, the subrogation right does not arise unless there is no liability to the mortgagor, and the recitation of law in support of that is patent in the opinion. And further, that the foreclosure was improper, not only the subrogation but the foreclosure itself, unless the insured was guilty of conspiracy in the arson, and the payment was not subject to an offset as respects the mortgagor. In addition, and while it was not commented on by the appellate division, Judge Breitel stated on behalf of this court in Whitestone Saving and Loan, a landmark case in the world of insurance law, that where the mortgagee, not necessarily an insurance company, but they're in absolute equal par with each other, that where the mortgagee bids in the full amount of the encumbrance, that there is no insurable interest remaining. And that is exactly the position that the insurance company finds itself in. Whether it was an error in tactic or otherwise, it nonetheless did just that. And in fact, on a further application to the county court in Dutchess County, Judge Kessler rejected an application by the insurance company for a deficiency judgment based upon the fact that they voluntarily acted in the manner that they did.
Mr. Wegg, can we come back for a moment? The unity of interest principle, recognizing you don't believe it applicable in this case, let's assume, and certainly not deciding it, but let's assume that is the rule of law substantively that underlies this, and that the trial judge intended to so charge the jury. Do you concede that he did not follow out on that intention and did not answer the jury's inquiry in that respect when they came back?
I believe, Judge Bellicosa, that he gave the jury the only possible instruction that he could if we consider this as a question of fact to be decided by a jury. There was nothing more he could have told the jury short of making a determination as a matter of law. There was nothing further. There was no way. I suggest that there is nothing that Mr. O'Connor, the trial attorney on behalf of the defendant, could have suggested to the judge in the way of language.
But underlying the question of fact that he might have intended to give to the jury has to be a principle of law that may become the law of the case on the charge, and that may be, in his mind, and I guess we have to look at it and reconstruct it, certainly I will, that the innocent spouse rule didn't apply, but that a separate exception to that or a separate rule with respect to the unity of interest might. And I gather that he did not so charge the jury if that is the underlying principle of law that should apply.
If I may juxtapose myself into the trial judge's thoughts, rather than make a determination as a matter of law on the record, he might suggest to himself, well, let's give the jury an opportunity to make that determination. Whether he would see fit to act upon that determination, if it were on behalf of the defendant or not, we don't know. But the only manner in which he could suggest to the jury that they determine as a question of fact the relationship or the culpability of the daughter would be to present it as he did, by recharging circumstantial evidence and recharging them on intent, and in fact stating that you can infer into the acts of Cheryl Ann anything that you think is proper under the circumstances.
But there is a difference between participation in the arson and unity of interest for purposes of the insurance and for ownership and things. Those really are two discrete things.
The latter is solely a matter of law, as I see. On the subject of a straw person, I believe, and as we state in our brief with supporting argument, that a straw person argument requires a purpose, a continuing transaction, if you will. It requires more than a passive participation on the part of Cheryl Ann. Her cognizance or awareness that she was the recipient of a gift with no quid pro quo does not constitute a straw person. I would suggest to the court that a very striking illustration of this could be had if we assume that the father, Russell Reed, with intent to exercise a sphere of influence over his daughter, burned the house and changing the only fact pattern I would change in it is that if she had purchased the house with her own money and he had burned the house anticipating that upon her receipt of the insurance proceeds he would Svengali her into giving him the money. Now, certainly that set of facts does not suggest even for a moment that the insurance company would have a right, in the absence of her culpability, in the absence of a conscious awareness of the scheme, that the company would have a right to deny liability or insulate themselves from payment.
Is the straw person concept any different from putting the property or the insurance policy in the name of a nominee?
Well, it depends on what the mens rea of the nominee is. If the nominee is accepting a gift, as is stated here, notwithstanding the fact that at the age of 18 she was, as the evidence indicated, subject to the will of her father, she certainly was not carrying out a conspiracy. She had, and the jury never found, and the jury in fact found to the contrary, had no guilty knowledge of any of the facts and circumstances surrounding the origin of the fire.
The straw person concept then, you say, does require some complicity and participation on behalf of the nominee.
Without any question, Your Honor. Without any question. You cannot have a straw person set up without that.
Is there really then a difference between that concept and the concept of complicity and fraud or whatever it might have been that was charged and submitted to the jury here?
Really not. It's a catchphrase. The question of fraud is what was submitted to the jury, and the jury could not have had anything else submitted to them unless the trial judge had decided as a question of law that the finding of arson on the part of the father constituted a bar to recovery on the part of the daughter. The specific questions on behalf of the daughter were asked. The emotional argument as presented by the insurance company is certainly persuasive. The insurance company is sitting in a position of having paid out $200,000 and some odd on the mortgage and is faced with the exposure of paying $186,000 additional. I find myself in an anomalous position. I'm an attorney who my practice is comprised exclusively of suing insurance companies on first-party insurance matters. And
I don't expect us all to cheer about that.
No, Your Honor, no.
Or even be sorry about it.
No, I'm not editorializing. I'm really saying that certainly from an emotional standpoint, I can understand the upset of the carrier, but this is a matter of law. The mortgage situation is one which was resulted from their own wrongful conduct, from their own error. And as a matter of law, there's no justification to set aside, particularly in view of the jury finding of the innocence of the daughter, to set aside the jury verdict. Additionally, Your Honor, I think it's pertinent to point out that this insurance company had total knowledge and total awareness of the circumstances and background of this risk before they insured it. In fact, the report stated that there was a transfer of title, and they said in the report the house was previously owned by a corporation controlled by Russell Reed. There was no material misrepresentation. There was no concealment. There was no justification on the part of the insurance company other than the profit motive of writing a policy. And under the circumstances, there was arson. It did act as a bar to recovery to the arsonist, but it should not to the innocent policyholder. I submit the cases recited on the subject matter, including Krupp, and the most recent case, Maravich of Pennsylvania Court in 1986, which recites the entire sequence of events and says that the concern is about collusion between the spouses, but we will not permit that to prevent recovery where there is an innocent
Thank you,
party.
Mr. Wade. People versus Alfred Washington.
Ready to call, please.
Wow.
Good afternoon, Your Honor. This case presents initially the reverse of the Dear Cole situation, and which existed in some other cases in which a decision stated to be on the law by the application of 470.15 sub 6 was deemed to be made as a matter of discretion in the interest of justice. This is a case that was stated to be as a matter of discretion in the interest of justice by the application of 470.15 4A should be deemed to be upon the law. That is the statute which not exclusively, but sets forth certain particular types of decisions which by statute, and the jurisdiction of this court is principally one of statute in criminal cases, is deemed to be on the law, on the facts, or the matter of discretion in the interest of justice. The two parts of that subdivision was the determination made that the defendant was denied a fair trial, and that's quite evident from the decision here. The constitutional error, constitutional magnitude, deprivation of a right to testify was the determination, and that was it duly protested in a manner consistent with 470.05 of the CPL. And what you have here is a request made to testify, and the statute says that if one without success, either expressly or impliedly, seeks a ruling, particular ruling, he's deemed to protest. Not only do you have the request itself, but you have reasons given, you have colloquy between the defendant, his attorney, and the court, which ultimately produced a complete record which led to the determination by the appellate division. Moreover, if you look at the text of the decision itself, the words that are used by the appellate division are words of a legal determination, an abuse of discretion rather than the phrase improvident exercise of discretion. You have fundamental rights, constitutional magnitude. It's a mandatory reversal situation. Plus, you have no discussion of the weight of evidence, of strength of the case, which you ordinarily would have in the classic interest of justice determination. But the primary concern here in this type of a situation is the fact that the decision here, when you look not only at the Washington case, but at the three cases together, Harami, Hendricks, and Washington, which led to this particular decision, is given binding precedential value by the appellate division. The decision here, after all, is virtually a quotation from the Harami decision several years ago. And an interest of justice decision has far less precedential value than a decision on the law. The decisions here have been treated by the Intermediate Appellate Court as if they were creating a rule of law. And for that reason, it is important that this court be permitted to review that legal determination. In the same way that this court set forth in the McRae case the distinction between a given probable cause determination and setting the standard for probable cause, there is a distinction between the ad hoc determination as to whether a defendant should have been permitted to testify and a delineation of the parameters of the constitutional right to testify, which implicitly was made here. The determination that a defendant following summations who merely says that he didn't realize he could no longer testify is held to have had his rights violated in an error of constitutional magnitude. That effectively is a determination that he had a constitutional right to testify, even though summations had been concluded.
As I take it, the trial court said that it was an abuse of discretion as a matter of law and a violation of the constitutional rights on the part of this defendant not to let him speak last.
The appellate division said that.
Appellate division said that.
Yeah, the appellate division said that it was, well, again, it's an implicit determination because the abuse of discretion language was a quotation from the Harami case of several years past. But they said that this was a similar circumstance from the Harami situation, Harami being a prior interest of justice decision, and incorporated the rationale of Harami that extending it, because Harami was pre-summation, to a post-summation case, and incorporated the reasoning that this was an error of constitutional magnitude which constituted an abuse of discretion, for which no harmless error analysis could be entertained. And that is a signal to future courts, in the Second Department particularly, that the similar determinations are going to be treated similarly. And we're facing the situation in which what then prevents a defendant from saying, well, now I have a constitutional right to wait till summations are over. And when I make the request after summations have testified, here's the Washington case as precedent for the fact that you must let me testify. Now, the appellate division may, in a given case, say that even if it is not a constitutional error, if it is not a legal error, were we the trial court, we would have nonetheless allowed him to testify. But that does not have the same precedential value, and that presumably would be made if this court determines that this is an issue of law and determines that it is an erroneous legal determination. That decision would be made with the benefit of this court's assistance in the parameters of what a constitutional right to testify, how long it extends, and would have all the hallmarks of an ad hoc determination, which does not necessarily mean that in a subsequent case where a post-summation request is made, that in that subsequent case, it must be granted as well.
And if I follow your argument, were we to agree completely with your position, the result would be to remit this to the appellate division for an exercise of discretion.
Well, I think that is within the authority of this court, if it wished to say, as it did in the Rickard case, to say that there was no abuse of discretion here. There was the constitutional right to testify did not extend to the point of this was no error of constitutional magnitude. But as the language out of the Rickard case is, but the intermediate appellate court is still free to substitute its discretion for the discretion of the trial court, even in the absence of abuse.
Well, we have no choice but to do that, do we, in terms of our limited authority and the authority of the appellate division, which includes exclusively, as an appellate court, the interest of justice review? Because if we can't do it, and you say, reading this, they haven't done it, then it's got to go back for that.
I have no problem with that result whatsoever. My concern in this case is the precedential value.
Well, let me come back to that as long as you have no problem with the other. And that is not the appellate division decision, both its decretal language and the memorandum, susceptible of another reading, that they do not, as you have advanced it, and I understand why you do, establish a broad fundamental constitutional right which will now replicate itself in all these cases. It seems to me that when you look at their memorandum, they only use the fundamental constitutional right language as a backdrop for moving into traditional abuse of discretion and interest of justice evaluation. And it may very well be that that's the precedent and the pattern, and that this is truly an ad hoc, as they said it was in their decretal paragraph, interest of justice consideration.
I think there are a couple of things to be considered in that. First is the fact that it was the blind mechanical application of a prior decision as if that prior decision were binding precedent. Secondly, there is no discussion in the Washington case itself except a brief prelude, a brief two-sentence articulation of the record. There is no discretionary ad hoc decision. There's no discussion of the fact that whether this was, again, a close question where compared to the dissent, for example, where the dissent goes into the fact that this is not a situation in which there's any articulation of any relevant testimony that the defendant had to offer. There's not a situation in this case where there's any history of prior conflicts with the attorney in terms of the disputes as to trial strategy. There's no discussion of the fact that this request to testify was an afterthought request by the defendant when he had been denied the pro se brief going to the jury, a pro se summation going to the jury, and additional adjournments to find witnesses. Those are the types of ad hoc considerations that you would expect to find in an interest of justice decision.
And you would require the appellate division to recite all those things rather than just say interest of justice in its order.
No, I would not require that. But when as in the Blakely case, where this court said in a determination that if you're trying to see whether or not the appellate division, well, it doesn't have to reverse on the facts or it doesn't have to make a determination against the weight of the evidence. You look at the decision to see whether or not it appears that they are, just look at what you have. They don't have to, they can write, in that case, an affirm no opinion. They don't have to put anything in the decision. But once they've written a decision...
I remember the case, but I don't remember those precise words.
Well, okay. But there is but you look at, it's not necessarily required that in every case a whole litany of circumstances be set forth. But when there are circumstances that would likely be discussed and are not, it certainly does give an indication that those were not the things considered, and that what was considered was the mere, as I say, mechanical application of the Harami decision, and citing also the Hendricks case. It's that Harami mandated the Hendricks result, and Harami and Hendricks mandated the Washington result. That to me is the clear implication of this decision. When the only legal discussion is a quotation of a similar case and a determination, the final, you said the decretal paragraph is important, but look at the sentence after the quotation from Harami. It's not the fact that we think a new trial should be granted or that a new trial is warranted in the interest of justice. It says the judgment must be reversed. Must be reversed. I don't want to play too much on semantics, but it has the implication that this is an error of a constitutional error which mandates a new trial from a legal standpoint. As to the merits of the question of where the constitutional right to testify, the line is drawn. The only way I can basically say it is the fact that if Alfred Washington's constitutional rights were violated, then effectively anyone who asks and is denied the opportunity to testify after summations, constitutional rights have been violated. This is the bottom line case. And if that's the case, then what you effectively have is a constitutional right to testify after summations. And I don't think that any notion of fair trial or due process incorporates that right. If the legislature wants to put into 260-30 that following the people's summation, if a defendant has not already testified, he may ask to do so, that's one thing. But until the legislature does that, it would seem that before a constitutional right to testify after summation exists, there must be some compelling problem which indicates either that ineffective assistance of counsel or an impediment to his having exercised that right at the appropriate time or something of that kind. No further questions. Thank you very much.
Thank you very much,
Your Honor.
Khan.
Carol Kahn for Mr. Washington. There is an impediment here, a very profound basic impediment, that Mr. Washington was never permitted to make an offer of proof as to what he wanted to testify to
As
later.
I understand it, you in your brief constantly talk in terms of a gag order.
Yes.
Or the court gagging Mr. Washington. Now, as I look through the transcript, it appears as though the trial was concluded. The court was actually beginning his charge to the jury when Mr. Washington said he would like to make a statement. At that point, the judge said, well, you had your opportunity to testify. The lawyer confirmed that, and he didn't want to testify. And he said, well, I don't want to testify. I just want to talk to the jury.
Well, Your Honor, first of all, I think the court made a mistake in accepting the defense counsel's statement that there was a voluntary knowing waiver. The language of the defense counsel's restating his defense counsel's conversation with Mr. Washington. Defense counsel said, I spoke with Mr. Washington and told him what his rights were and that he would likely do badly because of the Sandoval ruling. At that point, I didn't think Mr. Washington wanted to say anything more. I didn't know, and he hasn't said anything to me since then. What defense counsel was really saying was inferring a waiver from silence, which can't be done. The defendant should have had the right. At that point, he vociferously objected, so he clearly did not waive his right to testify.
Doesn't this occur to you as being a very unusual way to proceed in a trial, assuming this is precedent now, where in every trial a defendant can refuse to take the stand, and as soon as the judge begins his charge, the defendant jumps up and starts speaking.
No,
and
Your
if they
Honor.
don't let him speak, it's reversible error.
No, Your Honor. The only thing I would ask is that the court, because of the discretionary provision for adjustment of the order of trial in 26030 of the CPL.
Well, Olson speaks of that and talks in terms of the reasonableness and also speaks in terms of the discretion which is reposed in the trial judge.
But, Your Honor, in order for the judge to exercise his discretion within lawful bounds, if there's an abuse of discretion, that's reversible error. The court has to permit the defendant to make a record to show that the court would be abusing its discretion
Well, this
by not
court,
granting
this
it.
witness even said he wanted to put on witnesses, this defendant. He said, I want to put on witnesses.
Well, Your
and the
Honor-
judge then made inquiry. He said, have you got the witnesses here? And he says, I don't know where I can find them.
But, Your Honor, at least, all I'm saying, the court could have cut him short if the court had asked one question. What is the probative nature? What issue are you trying to prove? What is the point of your
He
testimony?
said it was all in my pro se brief. And then he said, will you let the jury read the brief?
Your Honor, I believe that he cut the defendant off at that point when the defendant tried to. He said, if you don't stop now, I will gag you. And Your Honor, I think because of that,
Well, he was going on.
because he wasn't permitted to make an order of proof, there is no record for harmless error. The burden, if you're denied your right to testify, that's a constitutional issue. Now, under People v. Crimmins, the burden of proof of harmless error is on the people. If there's no record for what the offer of proof would have been, there's no record to show that the abuse of discretion in failing to adjust the order of trial was harmless.
There are 2.5
people-
pages here where the judge asked the lawyer to explain exactly what went into the process with respect to the defendant not wanting to testify. And apparently the defendant said that doesn't object to not being able to testify. He just wants an opportunity to sum up before this jury.
I thought he said that he said several things. He said he wanted to testify and he wanted to do other things as well. I think there is a problem that he was forced to waive his right to, that his attorney implied a waiver of his right to testify by silence, that there wasn't proof of a knowing voluntary waiver. And because he wasn't allowed to make an offer of proof as to the probative nature of the testimony he would have given, that it wasn't harmless error, there's no way the people can show it was harmless error to silence him. Additionally, I don't think that there was a blanket application of Harami and the Hendricks case. Each one of those cases is very fact-specific as to why the Appellate Division Second Department reversed those two cases in the interest of justice. The first case, I think it has to do with the probative nature of the testimony in those cases, and at the point at which the defendant raised the issue that there was no showing on the facts of those two cases that there was prejudice to the people. And I was arguing, although the Appellate Division didn't mention it in their decision, I argued very fact-specifically in my brief because Washington had not been permitted to make an offer of proof, there wasn't a record on which the court could find, could make a harmless error analysis. And I thought that the appellate division bought that argument in their decision, where they say there was not a showing of harmless error, could not be established as a matter of law. Otherwise, I mean, the other alternative on the jurisdictional issue is that, yes, it is an error of law. It was preserved by both Washington's pro se protest and also by the fact that being threatened with a gag, he couldn't protest more. Any further protest would have been futile. And that it was error of constitutional magnitude, preserved even without objection, to deny him his right to testify where he had been gagged, he had been prevented from making an offer of proof.
You would agree with the appellant's argument that there is a legal question preserved for our court?
Basically, I argued it both ways. I mean, I think it's a very close question, and it could be taken either way. I don't think that the Harami-Hendricks reversal is a blanket reversal. I think the appellate division was trying to be very fact-specific. But I think that since he did protest, it might be considered an error of law preserved,
At least you're not arguing against that too vociferously.
No, I mean, I think you can argue it either way, and we ought to prevail either way, is basically my argument. That either it was properly an interest of justice reversal, or it's a fundamental error of law, but he was denied his right to make an offer of proof, and if he can't make an offer of proof as to the probative nature of his testimony, then what you're really doing is destroying the discretionary adjustment of the order of trial. Because if he has no record to show that he might have been harmed, how can you say it was not an abuse of discretion to deny his request for an adjustment of the order of trial?
The basis of your constitutional error is that he was denied an offer of proof, is that it?
Yeah, to me that's the problem. It's the judge who just said, well, what is it you want us to hear about? What is the point you're going to make? And then if he had said it's just X, and the court had said, well, you know, that's frivolous, I deny your motion, that would have made, I don't think he would have had a leg to stand on. To me, it's the
It's
Gann
not
order.
that he had a right. You're not arguing that as a matter of fundamental constitutional law, he had a right to testify after summation or to make a statement. You're
No,
not
he-
arguing that substantively.
No, I'm
are
arguing
you?
that he had a right to make an offer of proof as to what the content of his out-of-order testimony would have been, so that the court could then have a record for determining whether it was
But if there is no underlying constitutional right which might have persuaded the court to answer his offer of proof in his favor, which you concede there isn't,
well, I mean, he has a right
then
to
what difference
testify.
does it make?
He has a right to testify if his offer of proof is probative. And
Let's see if he had an offer of proof. He says, I'd like to speak to the jury. And the court says, about what? And he says, well, see, Your Honor, I feel that it's apparent that you contradict yourself to tell the jury that, first of all, I'm not required to explain myself and to suggest to them that I'm a man who stands here fully innocent of the charges, yet you happen to believe I have a fair trial, but place so many restrictions on my evidence, such as statements from my lawyer, evidence from the investigators. He was quarreling with the rules of evidence. Now, I don't see any offer of proof. This is what he says he wants to tell the jury. And the court says, Mr. Warren says, you proceed to deny me a chance to even explain he wants to explain himself to the jury. He wants his pro se brief submitted to the jury. He concludes with saying, you can shoot me at sundown. I mean, is this, it seems to me the judge was very lenient. Indeed, at one time I recall the defendant saying to the judge, you're very lenient.
well, I still think that it might have been, since he was speaking pro se and since it was ambiguous as to whether he had waived his right to testify previously, the judge should have maybe just framed the question, what specific legal point do you wish to make? I think that...
But let's assume that regardless of the specific legal point that he wished to make, at this stage of the trial, he had no fundamental constitutional right to make it.
Well, he
What
did, Your
difference
Honor,
does
if he
it
hadn't
make
waived his
then?
right to testify. I mean, I think one of the problems here is that there was that his waiver was very ambiguous because his attorney basically was trying to imply a waiver by silence, and and silence wouldn't be a knowing voluntary
But
waiver.
are you predicating your fundamental constitutional right argument on the waiver?
Well, it's a combination of the
Isn't
two,
that-
that he hadn't waived his right to testify, he hadn't understood that there was a time limit when he had to testify by, and also that he had a right to understand
But
that...
the appellate division in its decision finds that his attorney did waive that on his behalf.
Well, I think that I really thought that that was part of their discretionary reversal, that it wasn't preserved, that he couldn't preserve the issue of waiver because his attorney had waived it for him, and since it was unpreserved error, it would have been a reversal in the interest of justice, that there was an illegal waiver here of his right to testify. It wasn't preserved because his attorney didn't preserve it, so it would be a reversal in the interest of justice. That the interest of justice reversal was dual, that there was an illegal implied waiver of his right to testify, and also that he was denied the opportunity to make an appropriate offer of proof as to what he would have testified to out of order.
Thank you very much. People versus Richard Winkler.
Good afternoon, Your Honors.
Good afternoon, Ms. Elger.
On this appeal, there is only one major issue for determination by this court: whether there is any need for a special per se ineffectiveness of counsel rule in contingency fee cases. In urging on behalf of the people that there is no such need, I'm sure that this court understands that I am in no way advocating or condoning contingency fee agreements. They're prohibited by the Code of Professional Responsibility, and they're subject to disciplinary action. But the people's position is that the conflict of interest rules and the right to counsel standards already fashioned by this court are sufficient to protect the defendant's constitutional right to counsel in such cases, and that those rules better balance the interests involved than a per se rule would do. And before I go on this subject, I'd just like to point out two propositions set forth in defense counsel's brief that I think deserve mention. One is on page 11 of his brief, in which he states, "The people's entire argument rests on the possibility that respondent could inherit from his father's estate even if respondent was found criminally responsible for his father's death." I think it's clear, but I want to make sure that I point out that that, in fact, is not any part of a major position that the people are taking in this case. The people's argument rather rests entirely on the theory that the existing conflict of interest rules, as fashioned by this court, and which have worked well in conflict of interest cases, should be applied to this particular case. The other proposition in defense counsel's brief that requires a very short mention is the fact that he discusses plea negotiations. In fact, fully half of his legal argument is devoted to the proposition that in a contingency fee situation, there is a potential that the conflict may operate in that it may guide the lawyer not to engage in plea negotiations. That's a factual question that's not really the initial question before this court, but more importantly, that's a question that was never raised in the trial court. The defense counsel justifies it was in fact discussed in the appellate division decision in this case, but it was not raised in the trial court here. And on page 13 of his brief, in a footnote there, defense counsel says that, contrary to our position, the adverse effects of the contingency fee upon plea bargaining were fully discussed at oral argument before the appellate division. That would, of course, not raise the issue sufficiently in any event. However, I would just like to note that the possibility was raised by Justice Mullen, and defense counsel, of course, who was appellant in that court, agreed with it, and it was not discussed by me, so I wouldn't call that full discussion of the issue. In the right to counsel area, this court has so far fashioned a per se rule in only two situations that I could find.
May I see if I understand your argument? Assume we agree with you that there is no per se rule. Then do you say the question of prejudice which would go beyond the per se rule, was not raised below?
I would not even go so far as to say the defendant must show prejudice. A defendant must show that somehow his attorney's conduct of the case was affected. However, if the attorney's conduct of the case was affected in a way which objectively one could say was the correct way, still I believe the defendant would have the right to a new trial. He has the right to have a trial in which his attorney's conduct is not affected in any way, good or bad. So I wouldn't say that prejudice should enter into it. But I'm saying that the rules that this court has already promulgated are sufficient. He will get a new trial if, in fact, the attorney's conduct was affected, and the people will not be put to the burden, and the criminal justice system will not be put to the burden of retrying him if he can't show anything at all.
If there is a reversal here, it should go back for a hearing of some kind? I'm not
Well,
talking
of course,
about-
my position in the brief was that the record is sufficient to make the factual determination, but it may require a hearing, in fact, and in some other case, it might require a hearing. There's a factual determination to be made if this court should reverse and find that the regular conflict of interest rules apply and not a per se rule.
Because there are two factors here. One, the possibility of a plea to a lesser offense. That's urged, isn't it? And the other is not making a request for a lesser included offense, both of which might have redounded against the decision of the counsel to either make a plea or request a lesser included offense, and this would have redounded to the
Right, there's certainly
detriment of the defendant.
There's certainly factual issues to be determined. In his 440 motion,
Now,
the
that's
defendant...
beyond that, but those are beyond the per se rule.
They are determinations that would have to be made if the ordinary conflict of interest rules were found to be sufficient by this court, yes. They don't have to be made if there's a per se rule, he's going to get a new trial, and there's nothing to be found. And incidentally, with respect to your comment about the plea negotiations, there were in fact issues raised with respect to whether or not defense counsel should have or should not have, or was affected by the fee agreement in not requesting lesser included offenses. However, there was never any issue with respect to the plea negotiations, although the appellate division discussed it as a theoretical matter in its decision. Another case that the appellate division relied on as analogous to the instant situation, and in fact it is really not, is one of the few cases in which this court has found a per se violation of constitutional right to counsel, and that's in the Felder case. Of course, that bears no relationship to this case whatsoever. In Felder, the defendants were being represented by someone that they thought was an attorney who was not in fact an attorney at all. There was no way that a person could have represented any of those people from the very beginning of the case. This is not such a situation. This is a situation where we have an attorney admitted to practice in the state of New York, and there was nothing to stop him from representing this defendant. The Felder case is totally inapplicable, and the per se rule found there is not applicable either.
If a lawyer gives a guarantee of acquittal, that lawyer would never really negotiate for a plea.
He may or may not. I think that's a factual question.
Well, I mean,
if he gives a guarantee,
it would seem to me if the lawyer says, I'll represent you and you'll pay me X dollars if I get you off completely. Now, let's assume during the course of negotiations he's offered a wonderful plea. Isn't there a great temptation to think that perhaps he or she wouldn't consider that plea because that means that the representation would be for naught?
that's right. And there are factual determinations to be made in that kind of a situation. How big was the bonus? If this lawyer is getting $100,000 and the guy says, I'm going to give you an extra, a watch. I'm going to give your daughter a watch. If I'm completely acquitted, I'm really excited.
But let's
Or if
assume
the
that's
whole fee is a
fee.
contingency.
Yeah, the whole fee. The
That's
whole
right.
fee is a contingency.
That's right.
That's what I'm talking
An
about.
absolute factual determination to be made on the facts of each
Well, if
case.
the whole fee were a contingency, would that, do you think, on its face be prima facie bad?
I think it would be prima facie bad, but I do not think that necessarily it would have affected the attorney's conduct if, in fact, the client said, the discussions with the client beforehand indicated he wanted nothing less. He was not interested in any kind of plea negotiations. The attorney said, let me try and get you the plea negotiations. He said, no. He said, I want nothing but an acquittal, and if you get me that acquittal, I'll pay you $100,000.
See, what troubles me in that instance is that the attorney really does not then represent, perhaps it can be argued, I'm not making this a statement of fact, but it could be argued that the attorney in those circumstances, as far as perception is concerned, would not be representing the best interests of his or her client.
I absolutely agree with you. Number one, the attorney would be disciplined for that, obviously, as the attorney in this case was. Secondly, that client, if the facts as you stated them to me were shown, that client would get a new trial. There's no question about it. All I'm saying is that without any further factual inquiry, there is no need to place the burden on the criminal justice system. The rules this court has fashioned will sufficiently take care of the problem, and the defendant's rights will be enhanced.
So, Grace Hart, it seems to be placing a tremendous burden on the defendant. It's hard for me even to comprehend the sort of factual inquiry to which you submit the party.
Well, let me stick with this case then for the moment. There is, on the record, you have to remember, none of this was known to the trial court. None of this was known to the prosecutor. There was no allegation that anything went wrong that any one of us could see. Not only was the defendant so happy with he was so happy with his fee agreement that he increased it by himself. Now, afterwards, he says, there was something wrong privately that none of you guys knew about, and I want a new trial. Is there no burden on him? Does the criminal justice system have to give him a new trial for asking for a new trial? In this situation, when you look at the record, as I stated in my brief, I think it can be determined from the record, but I think that the issues of, if any factual issues are left, they can be determined at a hearing. Lots of hard questions are determined by hearings. I'm not saying that it would be easy. This is a situation where the defendant gets on the witness stand and he said, I had nothing to do with it. That's his theory. And now he's saying that his attorney's actions were affected. He didn't ask for certain things. Well, I think that a hearing would clarify exactly why weren't those down charges requested. They weren't requested because he wanted an acquittal or because it was inconsistent factually with his theory of the case. A hearing can determine that issue.
Do I take it then the corrective action that you're asking for, should you prevail, is not necessarily a reinstatement of the judgment, but instead of a new trial, a hearing on that issue alone?
A reinstatement was my argument that it could be done that way, but yes, a hearing rather than a retrial. I think the criminal justice system does not need that burden, and the defendant cannot, prior to his trial with an unethical attorney, he should not be able to make a prior agreement for a second trial and get it just by saying there's something that went on that you didn't know about, and now I want my new trial. I think he should bear some burden, whatever amount is appropriate, to make the appropriate showing. And, Your Honor, the rules that you have already fashioned are sufficient for this purpose.
Thank you very much, Mr. Isaacs.
May it please the court, my name is Robert Isaacs for the respondent. I submit that there are two very clear reasons why this court should affirm the per se rule announced by the appellate division. The first reason is that there is an actual conflict established in this case. And there's an actual conflict a priori. That is, there is no way that this contingency fee, where the fee is contingent upon a complete acquittal, is not in conflict with two basic defense functions: the plea negotiation function and the trial strategy function, where an attorney must look to see if there's a possibility of a verdict of guilty of a lesser charge.
Mr. Isaacs, but where is the state's responsibility in that regard, since this is a matter between the defendant and his counsel, with no knowledge in the prosecutor, no knowledge in the court, no opportunity to do anything about it? Where is the state action and involvement if we accept your premise that it's directly involved and not collateral?
Your Honor, I think the state's responsibility in this case rests with the defense bar. And I think that this case is, speaks to the same concerns that the facts in Gomberg spoke to. In Gomberg...
You suggesting that there's got to be an inquiry by the court then?
Well, I think Justice Mullen is correct. that there can't be an inquiry in this case.
This always puts it within the hands of the defendant then to have this backup ground for reversal, doesn't it?
Well, this is what the prosecutor suggests, but the prosecutor is neglecting one very important fact, that a contingency fee agreement cannot be entered into by the defendant alone. There has to be an attorney to enter into that agreement as well. And this is why I insist that the defense bar owes a duty to the state, owes a duty to the court.
They're not an agency of the state.
Well, Your Honor, in Gomberg, and this is why I alluded to it, this court, in referring to the trial court's duty to make inquiry of the defendant as to his knowing of the conflict and his consent to the conflict or the potential conflict, this court said, and I quote, that is, the trial court it may properly be assumed that an attorney will not perjure himself nor deliberately act in violation of the Code of Professional Responsibility. So even in the Gomberg case, this court acknowledged that some reliance must be made upon the defense bar.
But there's a triggering mechanism for the inquiry, and there's the same Code of Professional Responsibility that pertains here in terms of the defense bar or any lawyer complying with ethical responsibilities and disciplinary rules. There, what's involved is something that is evident at the threshold that triggers the inquiry, the conflict, two defendants. Here, the inquiry would have to go to every representation arrangement, because there's nothing that triggers it other than the fact that someone represents someone. And the court then, or someone, and as Judge Simons and you just exchanged, the defense bar in the abstract is not an agency of the state that can intrude itself into that relationship, certainly, to do anything about it. It's really what I'm struggling with in trying to satisfy my concerns about the case is, the element of control. What can be done with such a thing without giving someone an ace in the hole?
I don't think that this court can prevent contingency fee agreements other than through the sanctions that are imposed by grievance committees through the grievance procedure.
Why should the defendant benefit from that? And that's the point that Ms. Selker makes. In other words, in response to my question, she said, discipline the lawyer. The lawyer should not be able to do this. But then coming again, and I'm now piggybacking on the questions asked by Judges Bellicosa and Simons, why should the defendant have to, or be able to take advantage of this arrangement and walk free?
I don't think that it should be couched as though the defendant is a knowing perpetrator of a scheme to defraud the court and get a second bite of the apple if he loses a trial.
He will if he wins this case and then reads the advance sheets, as many of them do.
But in following this court's precedents, and specifically Gomberg and those cases that have applied Gomberg, such as McDonald, what the court should be concerned with, I respectfully submit, should be concerned with, is the unintelligent or unknowledge or uneducated defendant who is at the mercy of an unethical lawyer. We should not have the defendant who is not educated in the law, who is entitled to the right of effective assistance of counsel, to suffer on the assumption that he did this deliberately.
Well, presumably he would get his effective assistance of counsel if he established some prejudice, but why should he per se automatically get a new trial after he's been convicted if there's been no prejudice shown?
Well, Your Honor, as I had begun my argument, the first reason for the per se rule is that there is an actual conflict of interest with the basic defense functions.
Do you think
and
there's
no way
always,
to explain
there's
that
always
away.
prejudice? That there's inherent prejudice?
Your Honor, I think that the courts of this state, the decisions of this state, by this court, and by the United States Supreme Court, and specifically Holloway versus Arkansas, make it clear that where you have an actual conflict of interest, and specifically one that goes to the plea bargaining phase, prejudice is presumed, and nice calculations will not be entered into.
Assume a case where there could be no possibility of a lesser included offense, and there was no showing at any time that a plea bargain was possible. under the per se rule, the defendant will get a new trial.
Your Honor, as I had indicated, I think that the actual conflict is a priori in the sense that even if there is no possibility of a lesser included verdict, I cannot imagine a case where a defense counsel does not have the obligation to pursue a negotiated disposition. Even if the charge is merely disorderly conduct and nothing else, there still is the duty on counsel to see if he could get a plea to the charge with an unconditional discharge, for
Let us say
example.
let's say
There's
there-
always the possibility of a negotiated plea.
Let's say there were negotiations for a plea, at which point the defendant now says, I don't want to go on with these negotiations, I want a trial. I want either an acquittal or a conviction, I don't want anything else. And in fact, now I'll pay you $50,000 more, though, if you get me an acquittal. What about that?
Your Honor, I think Justice Mullen's observation about the conflict of interest shadow that is cast upon the advice which counsel gave to his client at that juncture.
My cases where counsel has advised him to take the plea, there's been plea negotiations, and he says, no, I don't want lesser included, I don't want to take a plea, I want to either be acquitted or found guilty, go on with my trial, and there's $50,000 extra if I'm acquitted.
First, the only way that this could be determined would be through a hearing. And if such a hearing were held, I submit that the court, the trial court, should not give weight to the attorney who has already proven himself to be one who can flagrantly violate the Code of Professional Responsibility. I don't think that a trial court should, as a matter of law, give that attorney the benefit of the doubt and assume that what that attorney is saying is true. As a matter of law, it must be assumed that that lawyer, in his efforts to negotiate...
He's a liar too, huh?
I don't think that as a matter of law, it's a meaningful distinction to make, to say that yes, he's unethical, yes, he will enter into an agreement that unethically strikes at the heart of the attorney-client relationship, yet we can rely upon him when he takes the oath. And we also have a defendant who is in desperate need of an attorney with undivided interests at the very outset of the proceedings, when he's arrested, when investigation has to be done, and perhaps investigation